ये मैटर जो मैं आपको बोलने जा रहा हूँ, आप इस मैटर को हमारे सॉफ्टवेयर पे टाइप करके आप अपनी मिस्टेक्स को जान सकते हैं और अपने शॉर्टहैंड को इम्प्रूव कर सकते हैं, जिसका लिंक मैंने अपने डिस्क्रिप्शन बॉक्स में दे दिया है।
Ready, start. The provisions of Order 22 Rule 9 CPC has been the subject matter of judicial scrutiny for considerable time. Now stop. Sometimes the courts have taken a view that delay should be condoned with a liberal attitude, while on certain occasions the courts have taken a stricter view, and wherever the explanation was not satisfactory have dismissed the application for condonation of delay. Stop. Thus, it is evidence that is difficult to state any straitjacket formula which can uniformly be applied to all cases without reference to the peculiar facts and circumstances of a given case. Stop. It must be kept in mind that whenever a law is enacted by the legislature, it is intended to be enforced in its proper perspective. Stop. It is an equally settled principle of law that the provisions of a statute, including every word, have to be given full effect, keeping the legislative intent in mind in order to ensure that the projected object is achieved. Stop. In other words, no provisions can be treated to have been enacted purposelessly. Stop. Furthermore, it is also a well-settled canon of interpretive jurisprudence that the court should not give such an interpretation to provisions which would render the provision ineffective or odious. Stop. Once the legislature has enacted the provisions of Order 22 with particular reference to Rule 9, and the provisions of the Limitation Act are applied to the entertainment of such an application, all these provisions have to be given their true and correct meaning and must be applied whenever called for. Stop. If we accept the contention of the learned counsel appearing for the applicant that the court should take a very liberal approach and interpret these provisions, Order 22 Rule 9 of the CPC and Section 5 of the Limitation Act in such a manner and so liberally, irrespective of the period of delay, it would amount to practically rendering all these provisions redundant and inoperative. Stop. Such approach or interpretation would hardly be permissible in law. Stop. Liberal construction of the expression sufficient cause is intended to advance substantial justice, which itself presupposes no negligence or inaction on the part of the applicant to whom want of bona fide is imputable. Stop. There can be instances where the court should condone the delay. Equally, there would be cases where the court must exercise its discretion against the applicant for want of any of these ingredients, or where it does not reflect sufficient cause as understood in law. Stop. The National Testing Agency conducts the NEET every year of admission into medical colleges. Stop. A total of 1,80,000 seats are available for the MBBS course. Stop. All the seats available for the MBBS course, approximately 56,000 seats, are in government hospitals and about 53,000 are in private colleges. Stop. Admissions to undergraduate course in dentistry, Ayurveda, Unani, and utilize the results of the NEET for admission. Stop. The NEET is divided into 4 segments comprising physics, chemistry, botany, and zoology. Stop. Each section contains 45 questions. Stop. The test comprises a total of 180 questions. Stop. 4 marks are awarded for every question which is attempted correctly, and 1 mark is subtracted for each incorrect answer. Stop. Questions which are not attempted attract neither positive nor negative marks. Stop. Hence, the test carries a maximum of 720 marks in total. Stop. The total duration of the test was 3 hours and 20 minutes. Stop. This year, NTA opened the online portal for registration for the NEET on 9/2/2024. Stop. NEET was conducted on 5/5/2024 for over 23 lakh candidates at 4,750 centers in 571 cities. Stop. The exam was also conducted in 14 cities overseas. Stop. Soon after the exam, it became known that the question paper was leaked or illegally circulated amongst some students prior to the conduct of the exam at Hazaribagh in Jharkhand and in Patna. Stop. First information reports were registered in multiple states including Bihar. Stop. Maharashtra, Gujarat, Rajasthan and Jharkhand. Stop. The Bihar police appears to have issued a press release stating that its economic offences unit had arrested 13 persons in Patna in connection with the leak. Stop. The Additional Director General of Police, Economic Offences Unit appears to have issued a communication stating that the Economic Offences Unit has not released an official press statement. Stop. When the results were declared by NTA on 4/6/2024, it emerged that conspiratory or grace marks were awarded to 1,563 candidates at certain centers who did not have the opportunity to utilize the entire duration of the exam. The compensatory marks were awarded upon the recommendations of the Grievance Redressal Committee constituted by NTA. Stop. Following the grant of grace marks, these candidates scored in the range of 20 to 720 marks. Stop. The investigation into the leak of the paper and the adoption of other unfair means by candidates was transferred from the Bihar State Police to the Economic Offences Unit in Bihar. Stop. The investigation was later transferred to the Bureau of Investigation. Stop. Direct NTA conduct a fresh examination. Stop. Stay the counseling process scheduled to begin from 6/6/2024. Stop. Direct all states to constitute special investigation teams to investigate paper leaks in their jurisdictions and to submit status reports on the same. Stop. Inquire into the examination process and results and make recommendations on how to improve the process of conducting the examination. Stop. Set aside the portion of the NTA information bullet that discriminates between wrong questions and questions having two wrong answers. Stop. Issue guidelines to prevent papers from leaking in the future. Stop. Direct NTA to correct and republic the results, ranks and percentiles based on the revised marks. Stop.